learned that I fell on the minority side. By the Constitution, the timeline for hearing and determination was below a fortnight, and so full versions of the judgment had to come later. My summarized dissent thus grasped only the compelling elements of the case. Today, I have the opportunity to set out my opinion in detail. The question before the court was whether the presidential election conducted under one and the same electoral process with 5 other sets of election for the Senate, National Assembly, county governors, women's representatives, and county assemblies had been so compromised by operational irregularity and illegality as to compellingly attract orders of annulment. I learned that the majority on the bench had come to the unreserved resolution that the presidential election was a nullity and that the electorate must return to the polls. The position is summarized in orders which have been given on the majority side, indicating precisely what was decided. Thus, vital issues turning upon the democratic principle, issues of the terms and essence of the Constitution, of the statute law, and of the judicial mandate in the interpretation and crystallization of functional dimensions of the legal process had been so cursorily dispatched, maybe in answer to policy objects, or to political persuasions, or to other general social calls. For me, as an experienced lawyer and judge, but more particularly as a dedicated legal scholar, such an approach to contentious matters did short shrift to the firm and principled normative configuration of the law and the legal process, elements which alone would temper the motions of the social and political order and ensure that the mechanisms of governance remain attuned to the ideals of civilized process. I will, in this judgment, examine the foregoing dimensions of law with greater focus after adverting to the pertinent issues and evidence in the whole course. Now, there was the main course brought by the petitioners, and there was the prelude. The petitioners were the presidential and deputy presidential candidates of the National Super Alliance coalition of parties, and were running on the Orange Democratic Movement Party and the Wiper Democratic Movement Party tickets, respectively. The first respondent is the Independent Electoral and Boundaries Commission, an independent agency established under Article 88, as read with Articles 248 and 249 of the Constitution of Kenya, and the Independent Electoral and Boundaries Commission Act 2011. The first respondent bears the mandate of conducting and or supervising referenda and elections for any elective body or office established under the Constitution, as well as any other elections provided for under the Elections Act. The second respondent is the chairperson of the first respondent and bears the mandate under Article 138(10) of the Constitution to declare the outcome of the presidential election and to deliver written notification of the same to the Chief Justice and to the incumbent president. The third respondent is the incumbent president, who was the candidate of the Jubilee Party and who was declared the winner in the elections on the 11th of August 2017. The petitioners are aggrieved with the mode of conduct of the presidential election of the 8th of August 2017. They contend that the said election was conducted, administered, and managed improperly by the first respondent, and that such mismanagement was deliberate and systematic, and having the effect that there was failure of compliance with the governing principles prescribed under Articles 1, 2, 4, 10, 38, 81, 82, 86, 88, 138, 140, 163, and 249 of the Constitution, with the Elections Act, with the regulations made thereunder, with the Electoral Code of Conduct, and with other relevant provisions of the law. The petitioners call for the invalidation of the second respondent's declaration of the third respondent as a duly elected candidate. The prelude to the main course is marked by a set of preliminary applications. I don't have to go to those. I've listed them so you will be able to read them for yourselves. It was the petitioner's contention that during the presidential election, being part of the general election of the 8th of August 2017, certain management improprieties came to pass, which affected the registration of voters, the votes cast, the vote count. One of the allegations related to the category of votes described as rejected votes, said to have constituted 2.6% of the total votes cast. The issue being raised in this regard came alongside a contention that an earlier decision of the Supreme Court of 2013 should be reversed, insofar as the court had in that case held that spoiled votes are not to be taken into account in computing the 50% plus one vote strength threshold for determining the winner in a presidential election. Such a claim is founded upon a desired legal yardstick rather than on the prescribed and operative law. The petitioners contended that the Supreme Court in the earlier case had improperly arrived at its legal threshold because it had been influenced by a dissenting opinion in a comparative case citation noted by this Supreme Court, which by Kenya's Constitution, Article 163(7), is the ultimate judicial authority, and, quote, all courts other than the Supreme Court are bound, end of quote, by its decision. The petitioners were invoking the case from Seychelles, Popular Democratic Movement Against Electoral Commission of 2011. They were urging that the majority stand in that case should determine this Supreme Court's position as regards spoiled votes in the electoral process, and that in that context there was an impropriety in the presidential election vote count following the election of the 8th of August 2017. The petitioners contended that the conduct of the presidential election of the 8th of August 2017 had contravened the principle of free and fair election under Article 81(e) of the Constitution, as read with Section 39 of the Elections Act and the applicable regulations. The burden of the petitioner's case lies on the process of relaying and transmitting voting records from polling stations to constituency tallying centers and the National Tallying Center. They questioned this process as falling short of the standards on simplicity, accuracy, verifiability, security, accountability, transparency, promptitude. They contended that such shortcomings had compromised the principle of free and fair elections in terms of Article 81(e), subparagraph 4 and 5 of the Constitution. The petitioners attributed impropriety to the electoral process on a plurality of grounds, such as 1, that the data and information recorded in Forms 34A at individual polling stations had not been accurately and transparently entered into the electronic kits at the individual polling stations. 2, that there had been non-compliance with the requirement that Kim's kits be accompanied by an electronic image of the prescribed forms, as these were transmitted to the National Tallying Center, and this was in contravention of Regulation 87.3 of the Elections General Regulations. 3, that the first respondent had predetermined the results of the presidential election and was therefore not impartial, neutral, and accountable as required by Article 81(e)(5) of the Constitution. The declared results were not verified in more than 10,000 polling stations, and the data entered in the electronic kits was not consistent with the information in Forms 34A. That the information in Forms 34A was not consistent with that in Forms 34B, and the figures were not accurate and verifiable. That the computation and tabulation of the results in a significant number of Forms 34B was not accurate, verifiable, and internally consistent. That the results recorded in the first respondent's Forms 34B were materially different from those relayed and relayed again as at the time of filing on the website. That the first respondent had espoused a false narrative, a national psyche, as the stage for stealing the election on behalf of the third respondent by allowing the electronic media and the news channels to relay and continue relaying its results data which lacked a legal or factual basis, and that at the time of declaration of election result, the first respondent was not in possession of Forms 34B and did not publicly display the same for verification. The petitioners contended that the presidential election was not impartial, not neutral, not efficient, not accurate, not accountable, as required under Article 81(e)(5) of the Constitution, as read with Sections 39, 44, 44A of the Elections Act and regulations made thereunder, and Section 25 of the IEBC Act, and that there were instances in which vote count had been distorted, manipulated, or inflated in favor of the third respondent. The petitioners asserted that it was impossible to determine who had won the presidential election or whether the threshold for winning the election was met. The petitioners contended that there had been a deliberate failure in the operational transparency and that the respondent had disregarded the decision of the Court of Appeal in Independent Electoral and Boundaries Commission against Maina Kiai, case number 105 of 2017, by failing to electronically collate, tally, and transmit accurate results, and by declaring results by county rather than by polling stations. The petitioners contended that the first respondent had allowed the transmission and display of unverified provisional results contrary to law, that the first respondent had also posted contradictory results in Forms 34A and 34B, and that there were internal contradictions in Forms 34A. They contended that the first respondent had declared final results on the 11th of August 2017, even before receiving results from all polling stations, and that allowed more than 14,000 defective forms from polling stations, with the outcome of distorting more than 7 million votes. The petitioners contended that the first respondent had colluded with the third respondent to eject their legitimate agents from various polling stations in Central and Rift Valley regions. On the basis of such allegations, the petitioners contended that the first respondent had abdicated its responsibility for ensuring a transparent and an impartial voting process, apart from corrupting the process of transmission of results. The petitioners contended that the first respondent had failed to adhere to the Constitution, rule of law, court orders and decisions, and that such a condition rendered the process of the presidential election the transmission of results, and the final outcome a nullity, as it lacked integrity, fairness, transparency. The petitioners contended that there had been a violation of Article 86 of the Constitution and that the votes cast in a significant number of polling stations were not counted, tabulated, and accurately collected as required under Article 86B and C of the Constitution, as read with the Elections Act. They contended that the results recorded in Forms 34A differed from the results shown in the first respondent's Forms 34B and displayed in the first respondent's website. And they asserted that the first respondent's Forms 34B were inaccurate, bearing statistical manipulation to favor the third respondent. The petitioners contended that the first respondent had acted contrary to the terms of Article 38, 81, 86 of the Constitution, as read with sections 39(1)(c) and 44 of the Elections Act and the regulations thereunder, as well as Section 25 of the IEBC Act. The petitioners contended that contrary to Regulation 7(1)(c) of the Elections General Regulations, the first respondent had fraudulently established secret and ungazetted polling stations wherefrom vote count results were added to the final tally, thereby undermining the integrity of the presidential election. The petitioners contended that a significant number of Forms 34B had been executed by persons not gazetted as returning officers and not accredited as such by the first respondent, and that such election results as were carried in such forms were invalid. They contended that all returns submitted without IEBC's official stamp or which did not bear the signatures and particulars of returning officers and agents were invalid. The petitioners averred that the returns used in a material number of polling stations were not in the prescribed Forms 34A, 34B, contrary to Regulations 792A and 87(1)A, and that the Forms 34B bore fatal irregularities affecting 14,078 polling stations out of the established 25,000. They contended that a number of the forms and returns were not signed, and they contended that some did not show the name of the returning officer, that some did not bear the IEBC stamp, that some Forms 34A and 34B did not bear the signatures of candidates' agents, nor the reason for lack of signature, that some were signed by some presiding officer serving at different polling stations. The petitioners contended that the first respondent had violated their rights under Article 35(2) of the Constitution by putting up inaccurate information which misled the general public. They also asserted that the presidential election was compromised by intimidation and improper influence or corruption, contrary to Article 81(e)(2) of the Constitution, as read with the Elections Act and Regulations 3 and 6 of the Electoral Code of Conduct. On the basis of the foregoing contentions, the petitioners formulated certain specific issues for the cost determination. These were: 1, whether the presidential election was conducted in accordance with the Constitution; 2, whether the presidential election was conducted in accordance with the written law; 3, whether the first respondent's non-compliance with the Constitution and or the law affected the result of the presidential election; 4, whether the first respondent's non-compliance with the Constitution and or the law affected the validity of the result of the presidential election; 5, whether the non-compliance, irregularities, and improprieties affected the validity of the results of the presidential election; 6, whether the non-compliance, irregularities, and improprieties affected the result of the presidential election; 7, whether the exclusion of 2.6% of the total votes cast as spoiled votes substantially affects and or invalidates the count and tally of the presidential election votes; 8, whether the total number of verified rejected votes should be considered in ascertaining the attainment by any candidate of the constitutional threshold. 9, whether the third respondent was validly declared as president-elect. 10, whether the said third respondent committed election irregularities. 11, what are the appropriate orders to be issued by the court? That brings us to the evidence question. What is the evidence? The various contentions and averments as a matter of vital judicial methodology are to be lighted up by objective evidentiary account. I will now consider the scope of validation for the petitioner's cause coming forth by way of their main body of factual testimony. The first respondent, Mr. Odinga, tendered evidence by his affidavit of the 18th of August 2017, which also represented the stand of the second petitioner. He deponed that he had been a presidential election candidate duly nominated by the NASA coalition. The first petitioner deposed that the first respondent, acting through presiding officers, undertook the vote count, which culminated in the declaration of the third respondent as president on the 11th of August 2017 with 8,203,290 votes as against the deponent with 6,762,224 votes. The deponent was aggrieved with the declaration as he believed the presidential election to have entailed breaches of the Constitution and the applicable laws. Such breaches arising before polling day as well as during the process of tallying and transmission of results. The deponent stated his belief that the presidential election failed to meet the constitutionally prescribed terms that require free, fair, transparent, accountable, credible, and verifiable elections. He deposed that the IEBC had deliberately and or negligently compromised the security of the Integrated Electoral Management System, the KIMS, and thereby exposed it to unlawful interference by third parties. He deponed that the collation, tallying, verification, and transmission of the presidential election results had been compromised by procedural flaws and illegalities upon such a scale as substantially qualified the credibility of the declared result. He averred that the poll results as declared were substantially at variance with the actual results tallied and declared at the gazetted polling stations. He deponed that the respondent, in concert with cabinet secretaries and others serving under the charge of the third respondent, had abused their positions by bringing their influence and pressure to bear upon the potential voters. The deponent averred that while the first respondent had acted by virtue of Section 44 of the Elections Act and developed the Elections Technology Regulations 2017, under which the KIMS system had been set up for the management of elections, the failings in the conduct of the presidential elections had now undermined the security of the electoral system, exposing it to third-party interference. He deponed that the said electronic system had been misapplied, with the effect that the presidential election was substantially conducted by manual processes. As an instance in that regard, the deponent averred that the first respondent acted contrary to law by failing to transmit electronically the vote count results from the polling stations and the constituencies, with the consequence that the transmission process was now exposed to unlawful manipulation. He averred, in that context, that the consequential delay in transmitting election results with the prescribed forms gravely affected the credibility and validity of the results. The deponent averred that a review of the election results in relation to the available forms 34A and 34B had shown substantial qualitative anomalies, such as put into question the credibility of the presidential election. The deponent averred that the third respondent was guilty of undue influence, bribery, inducement, and intimidation in relation to the free exercise of elective preference by the voters. In this regard, the deponent averred that the third respondent had, on the 2nd of August at Makueni, issued threats to those chiefs who did not mount political campaigns in his favor, that the cabinet secretaries had actively campaigned for the third respondent, that the third respondent had taken decisions involving public resource deployment in such a manner as to benefit his political campaign. Another deponent, Ms. Oichoe, averred that she was a cybersecurity expert and had observed and followed the conduct of the 8th of August 2017 general election, in particular the process of vote count results transmission. The process, as she averred, entailed 6 primary scenarios in respect of which IEBC's operational systems and database had to be tested. The first was confidentiality, the second was integrity, the third was authenticity. There are a number of them. And as far as she was concerned, the first respondent had failed in all those respects, and therefore the transmission system was entirely questionable. Another deponent, Mr. Koitameto Lekina, averred that he was a duly accredited agent of the NASA coalition in the general election of the 8th of August 2017. He deposed that he had arrived at the IEBC coordinating base, the Bomas of Kenya, on the election date at 16:30 hours for the purpose of activating his access card. Following some delay in activating the card, the deponent joined the company of fellow agents and they witnessed the streaming in of election results, which commenced at 17:15 hours. Thereafter, he averred his team came to learn that it was not possible to verify the result announcements as they came unaccompanied with hard copies of Forms 34A or the soft copies from the server. The NASA team, being concerned, approached IEBC commissioners, Professor Gulie and Ms. Roslyn Akombe, and the CEO, Mr. Ezra Chiloba, calling for Forms 34B as a basis of verification. As this initiative proved ineffectual, the deponent averred the NASA agents demanded a meeting with the Commission and obtained yet another fruitless promise of access to Forms 34A, these being received with Forms 34B only in limited numbers on the 11th of August 2017. The deponent recorded his opinion regarding the unreliability of the supply of Forms 34A and 34B by the IEBC, that this was evidence of a determination on the part of the Commission to declare results that could not be verified as required by law. The deponent drew on the content of another affidavit by Dr. Oduo and averred that dilatory responses to the demands for the said forms showed the first respondents' announcements to have been misinformed and or based on information such as failed the test of verification, accuracy, transparency, credibility. Mr. Moses Wamuru, the NASA presidential candidate's chief agent and coordinator for Embu County, deponed that he and his agent colleagues had not only been harassed but kept out of the polling station by IEBC officials and officers of the provincial administration for most of the election day. He deponed that he had been forced by the constituency returning officer to sign the election declaration form as a condition for being availed a copy of the election results. Another deponent, Mr. Godfrey Osotsi, for Amani National Congress of the NASA coalition, averred that he was an ICT expert who had been an observer of the August election vote tallying. This deponent deposed not upon the settled fact, but urged this court to order a system audit to trace transmissions so as to reveal the code used by IEBC for the more than 40,000 polling stations for the purpose of identifying the IEBC officers who used such codes to transmit election results, to establish the time and place where such transmissions were originated, and to identify the person who applied the special identifier to effect results transmission. The deponent also gave his opinion on matters of law, that under the Election Act, election material includes systems such as are contemplated under Section 17(1) and include the KIMS, which incorporates voter registration, voter identification, and the results transmission system. The deponent proceeds on that same line of averment. A declaration of results has to come in the wake of transmission in the right manner as prescribed before reaching the National Tallying Center. He rested his affirmations upon other deponents' statements in support of the petition. As at the time of declaration of presidential election results, only 29,000 forms 34A had been received, and their authenticity still stood to be ascertained, and election results could only be declared when the Commission was already in possession of all the forms 32A and 32B. The deponent averred that IEBC either lacked full control of its system or ceded such control to some other authority. Another affidavit was sworn by Mr. George Kegoro, the Executive Director of the Kenya Human Rights Commission, a civil society agency committed to fostering and safeguarding human rights, democratic values, human dignity, and social justice. He deponed that his organization serves as secretariat for an initiative known as Kura Yangu, Sauti Yangu, KYSY, which is wholly devoted to the cause of fair elections during Kenya's 2017 election cycle. He averred that KYSY had deployed some 500 agents in all the 290 constituencies to observe and monitor the electoral process, and KYSY had found contradictions and anomalies in the election data emanating from IEBC, especially in relation to the presidential votes as reflected on the IEBC website. An agent of the NASA coalition, Ms. Olga Karani, deponed that concerns had been expressed by members of the public about anomalies and irregularities in the vote tallying process. Such anxieties also coming from the election candidates as well as NASA agents. She averred that the prescribed election forms were manually availed to the National Tallying Center, though sometimes they were also displayed on the IEBC website. It was a belief that it was impossible to verify the authenticity of such forms. She deponed that by the time of announcement of the election results, the Commission had neither collected nor availed any of the Forms 34B, nor had it responded to outstanding issues regarding Forms 34A or to the questions being raised about results posted on the website. She attributed lack of transparency to the actions taken by the first respondent. Another deponent upon whose averment several of the petitioner's witnesses relied was Dr. Nyangasi Oduo, He deponed that on the 8th of August 2017 at 5:07 p.m., some 10 minutes after the closure of the polling stations, the first respondent started streaming results for the presidential election. He averred that such announcement of results had maintained a constant gap of 11% between the vote count for the first petitioner and the third respondent, notwithstanding the random distribution of the constituency locations. His averment expressed suspicion also on the basis that, as he perceived it, in numbers of polling stations within the central Kenya and Rift Valley regions, the petitioner's agents were chased away from the stations and replaced by imposters. And thereafter, presiding officers were caused to record fictitious results in favor of third respondent. Dr. Oduo averred that upon being asked by the petitioner to examine 5,000 Forms 34A supplied by presiding officers to the first petitioner's agents across the country, and to compare these with Forms 34B supplied by the first respondent and Forms 33A posted on the first respondent's website, he found discrepancies. Dr. Oduo made averments embodying opinion in clear terms. He asserted that third respondent and the deputy president, who are candidates in the presidential election, were guilty of corruptly influencing voters in the run-up to the general election of the 8th of August 2017. He averred that the election was compromised by instances of undue influence, inducement, bribery, intimidation. The deponent, in a second affidavit, avers that certain anomalies had compromised the said election, instances being forms marked with a rectangular rather than an official circular stamp, returning officers failing to sign Forms 34B or recording their own names, lack of handing over notes, discrepancies in numbers of valid votes, unstamped forms, corrected figures noted on forms, agents not signing statutory forms, discrepancies in vote tally. Discrepancy in vote tally records was also the subject of averments by Mr. Benson Wasonga, who deponed that the IEBC summation of valid votes was 15,179,717, with the first petitioner having 6,821,505, the third respondent having 8,222,862, and the total rejected votes being 477,195, as compared to the IEBC portal showing as total votes cast 15,181,381, first petitioner's vote as 6,821,877, third respondent's vote as 8,223,163, and rejected votes as 403,495. These figures, it was deponed, varied from the specific figures in Form 34C that were issued at the time of declaration of the third respondent as the leading candidate. Total valid votes as 15,114,622, first petitioner's votes as 6,762,224, third respondent's votes as 8,203,290, total rejected votes as 81,685. The deponent deposed that the actual variation in the rejected votes as between the IEBC summation of the results and the display on the portal was 73,700 votes, and he averred that this differential amounted to violation of the electoral law to the prejudice of the presidential candidates other than the declared winner. The petitioners called 2 more witnesses, one of these being Mr. Mohamed Noor Bare from Mandera, and the other one being Mr. Ibrahim Mahmoud Ibrahim, who said that they had been excluded from the polling stations. We have to look at the respondent side. Judicialism, the established framework for relieving the all-so-frequent grievances, conflicts, frays, and tensions in the social order, has evolved a civilized tradition of durable rules and methods of accommodation. Such methods have their objectivity and rationale lodged within the discipline of law, which, as will become evident in this judgment, is the domain not of the most open-textured manifestations, not the most elementary political suasions, but of jurisprudence as methodical reasoning of a normative and professional category. The established judicial method, which rests on the singular dependability of the fact base and which vindicates the principles of fairness, objectivity, and legitimacy, is to entertain the account from the other side, and therefore to weigh, check, and balance the two streams of evidence, thereby arriving at a valid and just result. As I express this introductory perception, so as to shed more light on the instant matter, I admit my debt to legal scholarship. With Andrew Goodman in his learned work, How Judges Decide Cases, in which he observes, quote, however rarefied and abstruse the legal argument before the court, it must be anchored on the facts of the case. While the judges will feel free to expound upon the most general principles in order to provide guidance for the future, the actual decision will turn on the facts, even if the detail of the argument is quite remote from them. End of quote. Such is a fundamental principle invariably observed in the practice and application of law in this country as in other countries, the constitutional and judicial systems of which have benefited from the integrity of the common law tradition. And such an approach is certain to lead to a fair, dependable, and plausible basis of judgment, as well as set a just and tenable reference point for the future. Let's look at the issues and contentions coming from the respondent side. It was the first and second respondent's assertion that the third respondent in the presidential election of the 8th of August 2017 had garnered the largest number of votes and had satisfied the constitutional threshold prescribed in Article 138(4) of the Constitution, apart from complying with the terms of the applicable statute law. They denied the petitioner's claims of non-compliance with the terms of Article 1, 2, 4, 10, 38, 81, 82, 86, 88, 138, 140, 163, and 249 of the Constitution, as well as other applicable laws, asserting that all such claims of non-compliance were couched in bare generalities and were devoid of any factual basis. The first and second respondents stated that the conduct of the presidential election had been attended with an elaborate management system guided by all relevant electoral laws and safeguarded by definite safety measures for assuring transparency, accountability, verifiability in terms of Articles 81 and 86 of the Constitution. The first and second respondents stated that they had duly verified and accurately tallied the election results for all candidates before declaring the outcome, in accordance with Article 138(10) of the Constitution, and duly taking into account the terms of the recent Court of Appeal decision in IEBC against Maina Kiai, Civil Appeal number 105 of 2017. They denied the petitioners' claims that they had conducted the electoral process in a manner that prejudiced the sovereign will of the voters, and that they had only delivered, quote, preconceived and predetermined computer-generated leaders, end of quote. The first and second respondents denied the petitioner's allegation that the number of rejected votes in the presidential election had been as much as 2.6%, and the total votes cast, stating that such votes as declared in Form 34C constituted only 0.54% of the votes cast. The first and second respondents contested the petitioner's claim that the right principle to guide this court in respect of the treatment of rejected votes should be that preferred by the Seychelles Supreme Court in popular democratic movement against Electoral Commission. The respondent's stand was that rejected votes had been rightly excluded from the count of votes cast by this court. The respondent stated that the process of relay and transmission of results from the polling station to the constituency tallying center and the national tallying center had been simple, accurate, verifiable, secure, accountable, transparent, and prompt. The first and second respondents stated that the presidential election had been conducted in a manner that was free, fair, and in accordance with the Constitution, a manner that gave fulfillment to the sovereign will of the voters. The respondents urged that in these proceedings, two basic questions fell for determination, namely, first, whether the third respondent was validly elected and declared as president-elect by the second respondent, and secondly, what consequential declarations, orders, and reliefs the court should grant. They asked the court to find, with regard to the two questions, that, firstly, the respondents had not contravened the provisions of the Constitution, the Elections Act, or any other statute. Secondly, the presidential election was conducted in accordance with the Constitution and the Elections Act and all other relevant statutes, and a valid declaration of the outcome duly made. Thirdly, that the third respondent was validly elected as the President of the Republic of Kenya. Fourthly, that the people of Kenya exercised their sovereign power of the vote and their decisions should be respected. Fifthly, that the petition lacks merit and should be dismissed. Sixthly, that the petitioners should bear the cost of the petition. We'll go through some of the evidential statements. The second respondent, in his affidavit sworn on the 24th of August 2017, deponed that he had been the returning officer for the presidential election of the 8th of August 2017. He averred that neither he nor the first respondent had any private stake in the election outcome, and they had been neutral referees, their sole mandate being to provide the electoral structure for the voters to exercise their sovereign will by electing leaders of their choice. The deponent averred that a tally of all the votes had shown Uhuru Kenyatta to have garnered 8,203,290 votes, followed by Raila Odinga, the first petitioner herein, who garnered 6,762,224 votes. The declared results were expressed in Form 34C, which was itself abstracted from Forms 34B, forwarded to the National Tallying Center from the constituency tallying centers as well as the diaspora vote tallies. The deponent averred that in view of the election management infrastructure that was in place, the primary results declaration forms 34A and 34B, were by no means compromised in their accuracy and overall integrity. These forms had been transmitted through the KIMS electronic system in a scanned format secured by non-replicable features. The security features, he averred, included anti-photocopy and self-carbonated elements up to a span subsuming 6 copies. He deposed that the presiding officers at the 40,883 polling stations were required to scan and electronically transmit the original Forms 34A to both the constituency tallying centers and the national tallying center. The constituency tallying centers, for their part, were required to relay the Forms 34B to the national tallying center for the purpose of tallying. And so, for the presidential election, the results could be verified by reconciling the figures in Forms 34A. The deponent averred that his dedicated task in the said electoral process was to provide policy leadership and strategic direction to ensure that the Commission's infrastructure for election management was accountable, efficient, systematic, methodical. He deposed that though afflicted by challenges occasioned by a multiplicity of suits against the Commission, it still ensured that the procurement of electoral materials by the Secretariat was done in a transparent and timely manner, and that other electoral processes, including supportive technological systems, were deployed in a manner consistent with the constitutional and legal requirements of simplicity, accuracy, verifiability, security, transparency, accountability. The deponent averred that all due arrangements had been made by the Commission in aid of the electoral process of the 8th of August 2017, noting in particular the following aspects. 1, voter education had been conducted throughout the country. 2, staff training for the management of elections had been duly carried out. 3, all the polling stations had been duly gazetted. 4, the register of voters had been duly audited and uploaded in the Commission's website, and hard copies printed and posted at conspicuous sites at each polling station. 5, mechanisms were put in place to facilitate the observation, monitoring, and evaluation of elections in compliance with the terms of Article 88(4) of the Constitution. 6, the procurement and distribution of strategic and non-strategic election materials was duly completed. 7, as required by Article 10 of the Constitution, the Commission had held many consultative meetings with key stakeholders, including, quite significantly, political parties, to update them on the progress made on all fronts in relation to the 8th of August 2017 elections. And 8th, the Commission had duly complied with the recent decision of the Court of Appeal in the Maina Kiai case on the conditions attending the tasks of vote counting, tallying, verification, and declaration of presidential election results at the constituency level and at the National Tallying Center. The deponent averred, in the light of the foregoing safeguard measures taken, that it was not true, as alleged by the petitioners and their witnesses, that the Commission presided over a shambolic presidential election, or that the entire electoral process was a failure, or that the election entailed breaches of the Constitution and the applicable laws relating to vote tallying and to the transmission of results. The deponent averred that the presidential election had met all the requirements of free and fair elections, having been conducted by way of secret ballots, being free from violence, improper influence or corruption, having been administered in a dedicated process conducted exclusively by the Commission, having been transparently conducted, and having been administered in an impartial, neutral, efficient, accurate, and accountable manner. The deponent, on the course of action which he took following the elections, signaled his authority as emanating from Article 138(10) of the Constitution. He is mandated within 7 days following the election to declare the result as set out in Form 34C and to deliver written notice of the same to both the Chief Justice and to the incumbent President. He averred that throughout the electoral cycle, he had discharged his mandate in perfect accord with the Constitution, the electoral laws, and the applicable regulations. He averred that in the discharge of his obligations at election time, he had not been influenced by anyone and had maintained the required standards of professionalism. The deponent deposed that he had conducted and supervised the election in accordance with the terms of Article 81E of the Constitution, and that in this respect, several elements in his discharge of duty stand out, namely, 1, every registered voter who participated in the general election had cast his or her vote by way of secret ballot. Secondly, polling stations were adequately secured by police to ensure that the electoral process was free from violence, intimidation, improper influence, or corruption. 3, the election was independently conducted by the Commission. 4, candidates and observers were allowed to have their appointed agents at the various polling stations to observe the voting process and to assure transparency. 5, the said agents observed the closure of the voting process and were involved in the counting of votes at the various polling stations to bear witness to manifestations of transparency, impartiality, neutrality, efficiency, accuracy, and accountability in the voting and vote count. And 6, the agents of the presidential election candidates were given access to the various vote recording forms, including Form 34A and 34B, a further element in the first respondent's transparency and accountability. The deponent averred, as regards the transmission set up during the electoral process, that the Commission staff managing the KIEMS gadgets had been trained in good time, and the said gadgets had been configured with the register of voters. He averred that the KIEMS system was designed to allow for integration of the biometric voter registration, biometric voter identification, the electronic transmission of election results, and the political party and candidate registration systems. He deposed that the said system had been successfully deployed on the 8th of August 2017, and that it had significantly improved efficiency, effectiveness, and accuracy in the operation of the electoral process. The deponent averred that he was present at the National Tallying Center between the 8th and 11th of August 2017, participating in the tallying and validation of Forms 34B that were being electronically transmitted by the constituency returning officers, and in this regard, he attached as evidence copies of Forms 34B marked WWC3. Upon receipt of these forms, he deposed, he had collated the same and confirmed the consistency of the results available Forms 34B to presidential election candidates through their agents for verification and confirmation. The deponent thereafter used the said results to tally and complete Form 34C in compliance with Section 39(3)(b) of the Elections Act. The deponent makes specific averments on the vote tallies as he received them on the 11th of August 2017. Now that chart is set out there, you'll be able to see it. The deponent averred that the Commission had found that in a few of the results declaration forms, there were certain errors, but that these errors were inadvertent, minor errors which had no effect on the vote tally and outcome of the presidential election. In support of the finding on the said errors, the deponent tendered in evidence a document marked WWC5, attended with a detailed affidavit of Madame Immaculate Kasait. Mr. Chebukati had specific averments to make in relation to certain depositions made on behalf of the petitioners. He deponed in relation to the statement by Mr. Godfrey Osotsi that throughout the electoral process, the Commission had engaged the petitioners as well as the third respondent in person and through their representatives, the public and interested stakeholders, for the purpose of adhering to best practices in electoral matters. The deponent, in departure from the testimony of Mr. Godfrey Osotsi, averred that the Commission was already in possession of all Forms 34B at the time of declaration of the presidential election results, and all the Forms 34B and 34C were available to the candidates and their agents for verification before the declaration of results. And all presidential election candidates were allowed to visit the National Tallying Center to verify the results, as from the commencements up to the moment of declaration. He averred that he personally chaired many consultative meetings with the petitioners' agents whenever any issues of concern had been raised, even though for an explained cause the petitioners' agents had decided to depart from the National Tallying Center just prior to the declaration of results. In response to the first petitioner's claim of procedural flaws, illegalities, and irregularities in the collation, tallying, verification, and transmission of presidential election results, the deponent averred that tallying as conducted by the Commission was in compliance with Articles 81E and 86 of the Constitution, as read with Section 39 of the Elections Act. And he deponed that at every forum of results processing, the petitioners were allowed to have their agents to confirm the tallying, the announcement, and declaration of results. He averred as well that the electronic system of transmission of results was secure, prompt, verifiable, and efficient. He deponed that all the results declaration forms had been subject to verification by the candidates' agents and their representatives, and immediately thereafter forwarded to the National Tallying Center. The deponent further averred that the first petitioner had deposed that he had been given access to the Form 34B through his agents, and thus the charge of lack of transparency and accountability in the tallying process was short on veracity. The deponent denied the first petitioner's assertion that IEBC had condoned voter intimidation, undue influence, bribery, and all flagrant electoral offenses committed by the third respondent. He similarly denied the assertion by one of the first petitioner's witnesses, Dr. Nyangasi Oduo, that the third respondent had been declared to be the winner without a verification of all the requisite documents. He averred that all the presidential election candidates and their agents or representatives had been invited to verify the results before declaration, and he deponed that he did not announce the final results of the presidential election until he had received and verified the Form 34B from the constituency tallying centers. The deponent averred that on the 10th of August 2017, the Commission received a letter of the same date from Mr. Orengo, the petitioner's deputy chief agent, raising concerns about the presidential election results, and the Commission internally considered the issues raised before communicating its position by letter of the same date, Exhibit WWC 6A and 6B. He averred that the declaration of presidential election results on the 11th of August 2017 was done in full compliance with the terms of the Constitution, contrary to the averments of the second petitioner. The deponent averred that the petitioner's allegation that the Commission had failed to take steps against the third respondent for breach of the provisions of the Elections Offences Act, Section 14, was not true. For on the 21st of June 2017, he had written to the Director of Public Prosecutions, informing him of the alleged breach and called for his action. The Director of Public Prosecutions had responded by his letter of the 6th of July 2017, Exhibit WWC 7. Another affidavit was sworn by the first respondent's Chief Executive Officer, Mr. Ezra Chiloba, who averred that the Commission had conducted the presidential election on the 8th of August 2017 in accordance with the terms of the Constitution, Articles 81, 83, 86, the Elections Act, and the applicable regulations. Mr. Chiloba testified that despite the complex political and legal environment in the run-up to the general election of the 8th of August 2017, the first respondent had managed to put in place an effective infrastructure. He averred that the election was conducted in a transparent, open, and accountable manner, and that the process was peaceful and credible, just as was confirmed by both local and international observers. In this regard, he annexed as evidence a copy of the various observer reports, Exhibit EC 12. The deponent averred that the tallying and transmission of election results took place at the polling stations, where the vote count was collated and declared at the Constituency Tallying Center and the National Tallying Center. Results thus processed and accounted for, the deponent averred, were in every sense credible and truly represented the will of the voters. He deposed that there had been no compromise to nor interference with the system for the transmission of results before, during, or after the declaration of the outcome of the presidential election. He deponed that the collation, tallying, and transmission of the results were in accordance with the terms of the Constitution, the Elections Act, and the appellate court's decision in the minor care case. Referring to the documentary evidence on record, the deponent deposed that the election results as declared were substantially consistent with and were a true reflection of the actual results tallied and declared at the duly gazetted polling stations. Responding to the assertions in the first petitioner's affidavit, the deponent averred that the electoral law had been recently updated with the enactment of the Election Laws Amendment Act 2017, allowing a 4-month period within which to procure and establish the KIMS system, and that there was no basis for the allegation that this new electronic system had been compromised through the practice of hacking, occasioning a distortion in the presidential election vote tallies. He denied the first petitioner's assertion that the first respondent had failed to put in place the requisite measures to assure the credibility of the KIMS system, and averred that the said system had served well in the identification of voters and for results transmission. He further deponed that the Commission's operations were not entirely dependent on KIMS, as a complementary mechanism was provided for by law in the event of any breakdown in the electronic system. The deponent denied the petitioner's assertion that the conduct of vote tallying in the presidential election had not been in accordance with the terms of Article 86 of the Constitution. He deposed that the election results had been transmitted from polling stations and constituency tallying centers as required by law. Denying the petitioner's statement that they were not supplied with forms 34A and 34B, the deponent averred that the petitioners had indeed been supplied with all forms 34A and 34B available on the public portal, and that by their own letter of the 14th of August 2017, the petitions acknowledged being accorded access to all the requested forms. Now, this is given as Exhibit EC 15. To the petitioner's assertions that Forms 34A and 34B had certain anomalies, such as brought into question the credibility of the presidential election, the deponent averred that the petitioners had not disputed the results as declared, but only alleged unsubstantiated qualitative anomalies. The deponent averred that all presiding officers had been trained by the Commission to take the image of Form 34A for transmission through KIMS, though there were a number of instances in which they chose to take images of other documents, and the consequence, in view of the fact that one of the security features was the capturing of only one image for the 6 sets of elections, was that it was the test documents rather than Forms 34A that ended up being transmitted. Upon noting this error, the first respondent uploaded the Form 34A for the affected polling stations on the public portal. Such inadvertent transmission of wrong images, the deponent averred, did not affect the election results as contained in Forms 34A. He annexed a typical example of such error as EC 18 exhibit. Responding to the petitioner's affidavit sworn by Ms. April Oichoe, the deponent averred that the assertions made under the rubric, quote, the travesty that was the electoral process in Kenya 2017, end of quote, did not give a true account. The report in question had not, in the first place, been dated or signed, nor was its author or source indicated. The deponent averred that, quite to the contrary, the first respondent's tallying and transmission system were functional and credible in all respects. In response to the affidavit of Mr. Benson Wasonga, the deponent averred that the election results from each polling station were contained in Forms 34A, and the results declaration for the presidential election was made on the basis of results contained in Forms 34B from 290 constituencies and the diaspora. He averred that the total number of rejected ballots as declared in Forms 34C was 81,685 and not 477,195 as alleged. He averred that Mr. Wasonga had misconstrued the statistics published on the public display mode of KIMS, which was not the result within the terms of the law. He deponed that the cause of the variance between the actual number of rejected ballots and the figure shown on the public website was but on account of human error. In response to the statements made on behalf of the petitioners by Mr. George Kegoro, the deponent firstly adopted the detailed tenor and effect of the first respondent's depositions by Ms. Immaculate Kasait. Secondly, the deponent averred that the statistics electronically displayed did not, as such, constitute the results of the presidential election. The final result of the presidential election is verifiable from an inspection of Forms 34A and 34B. The deponent denied Mr. Kegoro's statement that the IEBC's portal showed varying levels of votes cast for the 6 different elective offices featuring in the general elections of the 8th of August 2017. He averred that Mr. Kegoro's statement was unrelated to the fundamentals of the petition, as it lacked a foundation in the pleadings and the primary depositions of the petitioners, hence verging upon an attempt to litigate a substantial presidential petition by the guise of supporting affidavit. Responding to the affidavit of Ms. Olga Karani for the petitioners, the deponent adopted the averments made by Ms. Immaculate Kasait and Mr. James Muhati and deposed that all agents at the National Tallying Center had been given access to Forms 34A and 34B and an opportunity to verify the results before declaration. The deponent averred that the presidential election of the 8th of August 2017 was conducted in accordance with the Constitution and the electoral laws, and that the process was free, fair, and credible. Among the elements of credibility in the said election, he enumerated the following. 1. A substantial increase was realized in the number of voters from 14.4 million in 2013 to 19.6 million in 2017, being 78% of the eligible voters. 2. An audit of the register had been conducted before the date of voting. 3. The register had been opened for verification of biometric data by members of the public. 4. A timetable had been published for political party primaries, Gazette notice of the 17th of March 2017. 5. Resolving of disputes from the nomination process for candidates. 6. Registering of over 14,500 candidates to participate in the 2017 general election. 7. Gazettement of 40,883 polling stations and 338 tallying centers across the country, including the prisons and the diaspora. 8. Gazettement of returning officers. 9. Acquiring of an integrated electoral management system for voter registration, voter identification, candidates registration, results transmission. 10. Recruitment, training, and deployment of 360,000 election officials across the country. 11. Continuous voter education programs undertaken across the country using different strategies and platforms. 12. Attracting over 15,000 individual observers, 105 international observer institutions, 254 local institutions, more than 7,000 journalists from over 30 local and international media houses accredited to participate in the general election. The next deponent, James Muhati, who holds the office of Director in charge of Information and Communication Technology at IEBC, made depositions bearing upon the statements made by the first petitioner and by Ms. April Oichoe and Mr. Godfrey Osotsi. He averred that the commissions had taken up suggestions made in the Kriegler report, which was formulated in the wake of the violent election of 2007, and had deployed certain technological mechanisms to support the management of the electoral process, these being the biometric voter register, the electronic voter identification device, the candidate nomination system, and the result transmission system. When the new electronic system was first utilized in 2013, the deponent averred it was found to have certain imperfections, and it became necessary to amend Section 44 of the Elections Act, mandating IEBC to establish an integrated electronic system. This would facilitate the conduct of biometric voter registration, electronic voter identification, and electronic results transmission that is the Kenya Integrated Electoral Management System, KIEMS. This new system, the deponent averred, was successfully employed during the 8th of August 2017 general election, and it enabled IEBC to properly verify the biometric data during the 10th of May 2017 to 9th of June 2017 verification exercise as required by law. It also enabled the proper verification of voters on polling day, and it enabled the due transmission of election results from polling station to constituency and to national tallying center. The deponent averred that he was aware of the terms of the Constitution and the statutory and regulatory framework within which the electoral process had been conducted, and in this context he cited Articles 81, 86 of the Constitution as read with Section 4M and of the IEBC Act, which required the voting setup to be simple, accurate, verifiable, secure, accountable, transparent. He deposed that the KIEMS had been established with the approval of the Elections Technology Advisory Committee under the terms of Section 44(8) of the Elections Act, and with the participation of relevant agencies and institutions, including political parties, and he attached the relevant document exhibit JM1. On the role of ICT in general election on the 8th of August 2017, the deponent averred that a technological process had been used in voter identification and the transmission of results, and that the transmission component in KIEMS had enabled the Commission to relay the presidential election results and statistics from the polling stations to the constituency tallying centers and to the national tallying center. During the transmission of election results through KIEMS, the presiding officer would complete Form 34A as required by law, and then input on the KIEMS the results statistics captured on Form 34A. The presiding officer would then take the image of Form 34A, and before sending the data, he or she would first show the entries made to the agents of the candidates and of the political parties for confirmation. He annexed as evidence copies of the directions issued to the presiding officers, the training manual, and the transmission flow chart JM5A, JM5B, JM5C, respectively. It was the deponent's evidence that the petitioner's allegations that the delay and transmission was not simple, accurate, verifiable, secure, accountable, transparent, open, and prompt, and that there had been a contravention of the terms of Article 81, E, 4, and 5 of the Constitution did not represent the truth, especially as no evidence had been adduced to support the claims. On the question of the security and verifiability of the electronic system, and in relation to the allegation that there had been some compromise to the KIEMS system by unauthorized third parties, the deponent averred that such claims have no relation to the true position, noting also that they are not supported by evidence. He averred that the Commission had engaged a competent support team of experts who subsequently partnered with internationally recognized and accredited institutions to provide the best information security system, and he annexed the relevant exhibit JM8A, JM8B, JM8C, JM8D. The deponent gave testimony on the complementary system in the transmission of election results for compliance with the terms of Article 38 of the Constitution. He averred that Regulation 83 of the Elections General Regulation 2012 provided for the complementary system of transmission of election results, and that the complementary mechanism involves the physical delivery of Forms 34A by presiding officers to the returning officers in the respective constituencies. IEBC's Director of Voter Registration and Electoral Operation, Ms. Immaculate Kasait, averred that contrary to the negative impression given by some of the petitioner's witnesses on early transmissions of election results for some stations, such stations had only a few voters, sometimes numbering between 1 and 10, and counting these would take only a short time. She gave examples in this regard of Boyani Primary School in Matuga constituency, Arabro in Wajir South constituency, Ya Algana in North Hor constituency, Lowangena Primary School in Tigania East constituency. The deponent denied the veracity of the claim by some of the petitioner's deponents that there had been in the transmission of election results a constant 11% difference in vote strength between the first petitioner and the third respondent. She displayed a table in her affidavit based on a 30-minute interval analysis of transmitted election results data, and this showed the vote difference to range in percentage between 9.095% to 25.573%. The deponent denied the allegation in Dr. Nyangasi's affidavit that the first respondent had chased away from polling stations the agents of the first petitioner in central Kenya and in Rift Valley. She gave examples of polling stations in central Kenya in which indeed the petitioner's agents had duly executed forms 34A. The deponent admitted a case of an erroneous entry of data in a station where the petitioner had been credited with 2 votes instead of 561 votes, indicating that the circumstances in which such error occurred were explained in the first respondent's affidavit, Mr. John Ole Taiswa. She deponed that a similar explanation of error was also set out in the affidavit of Ms. Rebecca Abwaku. The deponent took on specific instances in which the depositions made for the petitioner and which attributed misrepresentation of vote count were based on untrue perceptions of fact. For instance, that a partial Form 34B was uploaded in respect of Karachuonyo constituency. That in Kilome constituency, the original Form 34B reflected 38,269 votes, while that uploaded in IEBC's portal showed 33,757 votes. That in Igembe South, the summation of total votes in Form 34A for the first respondent was 41,834, yet by Form 34B in the Commission's portal, his total votes were 43,209. That the Forms 34A in respect to St. John's Primary School polling station indicated the total number of valid votes cast as 468 against the entry on Form 34B, which showed 467. That there was a variance between the Forms 34B keyed in on the Kim's kit and that projected at the National Tallying Center for Morrison Primary School polling station. That there were any discrepancies in Forms 34B for Embakasi South constituency and Forms 34A for Jobena Community School. That there were any discrepancies in Forms 34B and 34A in respect of Kiru Primary School polling station. The deponent, while disagreeing with most of the claims made by the petitioners, admitted the occurrence of certain errors. For instance, there were discrepancies in Form 34B in Bomet Central constituency to the extent that at Bomet Primary School, the form did not show any rejected votes, while there was 1 rejected vote. In the case of Kapkoros Primary School in Turbo constituency, there was a computation error, though the total vote cast in respect of each candidate was correctly tallied. There was a computation error in the case of Dagoretti North constituency, with the total valid votes being shown as 104,789 rather than 105,840. In the case of Naivasha constituency, there were arithmetic errors in the completion of the forms for several polling stations. In the case of Kiangai Primary School in their constituency, Form 34A indicated the third respondent's votes as 461, while Form 34B showed these as 467. There was a data entry error in the case of Game constituency, with a variance between the total votes tallied and the total valid votes. The third respondent made depositions to the effect that he had at all material times been the President of the Republic of Kenya, as well as the nominated presidential election candidate for the Jubilee Party following the earlier general election of the 4th of March 2013. Regarding the integrity of the first respondent in his conduct of the 2017 general election, the third respondent deponed that the IEBC was a reconstituted team, drawing its origin from the endeavors of NASA, of the NASA coalition's predecessor, CORD, which in May 2016 had held nationwide rallies culminating in the removal from office of the former commissioners and the amendment of the Elections Act. The said protest led to a bipartisan parliamentary process which crystallized a new legal framework attended with the resignation from office of the then commissioners and the appointment of the current commissioners who managed the elections of the 8th of August 2017. The deponent averred that the presidential election of the 8th of August 2017 had been preceded by considerable litigation on electoral matters in the superior courts, promoted by CORD and NASA coalition, notably the minor Kiai case. There was also NASA against IEBC, Republic against IEBC, ex parte Gladwell Otieno. Those are examples. It was the third respondent's perception that the Commission had complied with the law in the conduct of the general election of the 8th of August 2017, especially with directions issued by the courts in the various election-related cases. This perception is founded upon a certain set of facts as follows. 1. Election materials, including biometric voter verification kits and ballot papers, were timeously conveyed to all polling stations in the country at large. 2. The biometric voter verification kits were successfully applied in all polling stations. 3. The voting process came up against no impediment throughout the country. 4. Candidates and all their agents and political party agents were allowed in at the polling stations to monitor the process of voting, tallying, recording, and transmission of results. 5. Presiding officers at each polling station not only submitted Form 34A in electronic form in the presence of the candidates and all their agents, but submitted also the scanned copy of Form 34A to the constituency tallying center. 6. Other than minimum human errors, which are to be expected, the data entered in the KIMS, particularly with regard to votes received by the individual presidential election candidates, was accurate. 7. Nonetheless, the results electronically transmitted through KIMS were only provisional and did not constitute the final figures which were announced by the second respondent. It is notable in this regard that the first respondent had made it clear that in the event of any difference between the alphanumeric results sent through KIMS and the results reflected on the Forms 34A, the results on the Forms 34A would prevail. 8. At each constituency tallying center, the Forms 34A received from the polling stations were collected by the returning officer, and a declaration in the Form 34B reflecting the same was signed by the returning officer and the candidates or their agents, verifying that the Forms 34A received were a true reflection of the vote count recorded by the presiding officers at the polling stations. 9. The signed Forms 34B were thereafter scanned and transmitted to the National Tallying Center electronically. 10. All transmitted Forms 34A were held accessible to all parties, and all Forms 34B were printed and availed to the presidential election agents at the National Tallying Center. 11. The presidential election results were declared by the second respondent on the basis of the results declared in Forms 34A at the polling stations and tallied in Forms 34B at the constituency tallying centers. The third respondent deponed that the petitioners had failed to set out the particulars of the non-compliance with the Constitution and the law, which they alleged by the first respondent. Hence, their charge had rested merely upon conjecture and speculation. As to the petitioner's contention that there were discrepancies between the Forms 34A and 34B bearing the election results, the third respondent averred that no instances of such variance had been shown, and in his perception, even assuming such allegations were true, the discrepancies would stand as no more than clerical errors, such as would affect the election results in view of the large difference separating the third respondent and the first petitioner in vote strength. The deponent averred that it would not have been possible for the first respondent to manipulate or distort the votes cast and counted in favor of the third respondent, considering the rigorous statutory procedures observed by the first respondent, and moreover, the final results of the presidential election had been duly verified by the political parties and individual candidates through their agents, the effect being that such election results were a true reflection of the will of the voters. In the third respondent's perception, the first respondent, in the conduct of the general election of the 8th of August 2017, had all along acted in a lawful and transparent manner as it undertook the tasks of various stages of the election, including early preparations, voting process, vote counting at the polling stations, tallying at the constituency and the national tallying centers, and the transmission of results at all levels. The mode of conduct of the election, in the third respondent's perception, was efficient, accountable, accurate, credible. The third respondent averred that he had garnered at the presidential election of the 8th of August 2017 a substantial vote represented in the figure of 1,401,286 above the number obtained by the first petitioner. Such a margin, in the deponent's view, emphatically demonstrated the sovereign will of the Kenyan people, which made it safeguarded by the process of the law. The third respondent denied the petitioner's contention that he had contravened the law and the declared principles for the conduct of free and fair election through the medium of intimidation, coercion, or improper influence on voters. He averred that such allegations had been made without any evidentiary basis. He deponed that the presidential election had been conducted peacefully and in accordance with the law as well as best international practice. The third respondent deponed that he had difficulty in responding to accusations emanating from the petitioners and their witnesses, which were imprecise and lacked particulars. While he found Dr. Nyangasi's depositions to be in the category of such generalized statements, he nonetheless went on to deny that he corruptly influenced voters in the run-up to the election of the 8th of August 2017. He denied that he had used threats to get support from local chiefs in Makueni. He denied being aware of any cabinet secretaries who abused their offices and accorded him electoral support, and invoked several other affidavits in support of his averments, those by Dr. Kibicho, Mr. Wakahiu, Mr. Chirchir, and Ms. Guchu. Mr. Chirchir, who had been the chief presidential agent during the 2017 elections, deponed that the said elections had been free, fair, and accountable, credible, and verifiable. He deponed that the majority vote cast for the third respondent was a natural reflection of the general national voting orientation, which gave the third respondent's Jubilee Party the greatest number of votes for the 5 other categories of elective posts also failed through the same general election of the 8th of August 2017. Denying the averments in Mr. Kegoro's affidavit for the petitioners, the deponent averred that the processes of voting, collating and tallying of votes, and declaration of results had been conducted in compliance with the provisions of the Constitution and the electoral laws, and that the presidential election results announced by the second respondent on the 11th of August 2017 were accurate and in compliance with the prescribed standards. The deponent averred that at the time of declaration of the presidential election outcome, the first respondent's online portal had not yet transmitted all the results, and these results were being retrieved from Form 34A arriving from polling stations, which results had already been transmitted to the constituency level, and the inconsistency in the data displayed was on account of Forms 34A, 34B, and 34C that had not yet been transmitted on the online portal. He deponed that as at the 21st of August 2017 at 8:14 a.m., the transmission rate was 99.99%, and this meant that the reported valid votes in the figure of 15,180,381 at the portal did not include all valid votes from all the 40,883 polling stations of the country. It was Mr. Chirchir's averment that the violence witnessed several days following the declaration of results by the second respondent was occasioned by the demands by the petitioners that they be declared president-elect and deputy president-elect on the basis that the petitioners were already in possession of what they believed to be the genuine results secured from the first respondent's servers. Such a crisis, the deponent averred, had been deepened by a press conference in which the petitioners urged their supporters to reject such vote count results, as would later be announced on the basis of a collation of results in Form 34C. Mr. Brian Gichana Omwenga, a technology advisor employed by the Jubilee Party, averred in his affidavit that it was not true, as deposed by Mr. Olekina, that Form 34A had been used to declare the presidential election results. Rather, he deponed, it is the Form 34B that provide the basis for declaring such results. Mr. Ojwang deponed that the process of electronically transmitting presidential election results had not, in all cases, functioned without a hitch. Sometimes the scanned image would fail to load or would delay in loading, especially in those parts of the country that lacked the 3G or 4G network coverage. It was his testimony that such network challenges had been anticipated, and so the first respondent had duly sounded necessary caution. However, the deponent averred, regardless of whether the electronic system duly functioned, the Forms 34A would still be physically delivered at the constituency tallying center, and the Forms 34A would then be used to tally the constituency votes, and thereafter the results would be entered in Forms 34B. The Forms 34B would then be transmitted to the National Tallying Center, where the Commission would sum up in Form 34C, which would be the basis for declaring the results. Consequently, the deponent averred it was not necessary to have Forms 34A in possession during the summation of presidential election results. It followed, therefore, that the early voting results transmitted on television screens were only provisional, and the authoritative results would be based on the constituency tally in Forms 34B. Dr. Karanja Kibicho, in his affidavit sworn on the 24th of August 2017, carries depositions focused upon the statements made on behalf of the petitioners by Dr. Nyangasi Oduo. He averred that in his capacity as Principal Secretary in the Ministry of Interior and Coordination of Government, he had in July 2017 received information that some chiefs in Makueni were unlawfully using their positions as well as government facilities to participate in political campaigns, whereupon he duly informed the third respondent, who issued the necessary warning to halt such practice. Ms. Mary Karen Kigen Sorobit, the Jubilee Party's Deputy Chief Executive Officer, made depositions in response to the statements of Mr. Wamuru for the petitioners. She averred that Mr. Wamuru had cited non-existent polling stations and claimed that the NASA coalition agents had been excluded from certain polling stations. The deponent annexed evidence in the form of Form 34A, showing that one Miss Eunice Mudhoni Ndwiga had been the NASA agent at the Karurumo Youth Polytechnic Polling Center and had duly signed the form without any reservation. The deponent averred that Mr. Benson was for the petitioners has stated that there were anomalies in the declaration of presidential election results, though without specifying the particulars of such anomalies. She deposed that the summation of the total valid votes in the portal is 15,001,381, and that by Form 34C, the first petitioner's votes were 6,762,244, while those for the third respondent were 8,203,290. Ms. Winifred Washeke Gushu saw an affidavit on the 24th of August 2017 in her capacity as the Executive Director of the Jubilee Party and Deputy Chief Presidential Agent for the third respondent. She averred the difference of 1,441,066 votes that separated the vote tallies of the third respondent and the first petitioner was a strong enough signal by the voters who are expressing their free and sovereign will, and she perceived it as relevant to the orientation in political choice, that the Jubilee Party won the majority of elected positions for the office of county governor, senator, member of the National Assembly, women's in the National Assembly, and member of county assembly, all from the same general election. The deponent averred that the petitioners had on the 10th of August 2017 written a letter to the first respondent claiming to have presidential election results which differed from the results being shown on the IEBC portal at the time. And just before issuing this letter, the petitioners had made widely publicized claims that the results transmission system had been corrupted through hacking. The deponent averred that the Constitution imposes no duty on the first respondent to use electronic systems of results transmission exclusively, the only mandate of the first respondent being to ensure that the electoral system is simple, accurate, verifiable, accountable, and transparent. She averred that Section 44A of the Elections Act entrusts to the first respondent a statutory discretion to apply a complementary mechanism where technology fails or cannot meet the constitutional threshold of a free and fair election. The deponent averred that upon the conclusion of voting, the counting had begun in the presence of all agents present, observers, police officers, and all authorized persons. She deponed that according to ELOG, an observer group which deployed one of the largest observer delegates, the petitioners a good representation of agents. She believed that even where such agents failed to sign the prescribed forms, such failure would not invalidate the vote count results in the light of the terms of Regulation 62, Subregulation 3, and Regulation 79, Subregulation 6 of the Elections General Regulations 2012. She deponed that once the counting process at the polling station was concluded, the results were simultaneously dispatched electronically to the constituency tallying center and the national tallying center, and these were the results which then streamed onto the public portal at the Bomas of Kenya. The deponent averred that since the first respondent did not own telecommunication network facilities, it relied on licensed service providers. Such service providers were under obligation under Regulation 20 of the Elections Technology Regulations 2017 to provide and deliver services as may be requested by the first respondent. The first respondent, in consultation with the service providers, was required under Regulation 21 of the said regulations to identify and communicate in a timely manner to all stakeholders about the network service available at different polling stations and in areas where there is no communication network. Thus, the deponent averred Parliament introduced Section 44A to provide a complementary mechanism for the identification of voters and the transmission of results. The deponent averred that after the Court of Appeal decision in the Maina Kiai case, it had been confirmed that Regulation 83 would be the complementary system applicable in respect of the transmission of election results in the event of failure of the technological mechanism. The complementary mechanism would take the form of the physical delivery of Forms 34A from the polling stations to the returning officers at the constituency tallying center, while constituency returning officers would deliver Forms 34B to the national tallying center in Nairobi. The deponent made averments regarding the claim of irregularity in the elections appearing in Dr. Nyangasi Oduo's affidavit. She averred that in the overwhelming majority of cases cited by Dr. Oduo, the statement had not revealed the features typified as irregular. She deponed that neither the Elections Act nor the Election General Regulations requires that Form 34A should bear the first respondent stamp, and the failure of an agent to sign the form counting hall did not invalidate the results. In response to allegations of discrepancies in Forms 34A and 34B, the deponent averred that no significant variations existed. She produced a report, XWG 13, which showed that after reconciling the discrepancies in the forms attached to Dr. Nyangasi Oduo's affidavit, the effect was that the petitioner's vote tally improved by 595, while that of the third respondent decreased by 1,199 votes. The deponent responded to the deposition from the petitioner's side that the final tally of presidential election votes had not included the results for Nyando constituency, where the first petitioner had obtained 60,715 votes, while the third respondent obtained 214 votes. She deposed an oversight was not fatal, as by Regulation 87 of the Election General Regulations, the second respondent has authority to declare the presidential election results where, in the opinion of the Commission, results not yet received would not make in the final results. Responding to the claim by the petitioners that there had been a suspicious disparity between the presidential vote totals and the totals for the other elective offices in the same constituencies, the deponent exhibited an analysis of results from 94 constituencies, showing that the votes cast in one or more of the 5 other sets of elections were more than the votes cast at those levels for the presidential candidates. The deponent denied the allegation made in affidavits to petitioners that the voting results streamed by the Commission had shown a constant 11% margin between the vote count for the first petitioner and for the third respondent. In line with other depositions for the respondents, she stated that such a gap in vote count percentages had kept shifting constantly. The deponent responded to the averment from the petitioner side that the third respondent's electoral strength had benefited from running governmental actions which showed him in positive light and thus constituted censurable and due influence. She averred that there was no requirement in law that ongoing government programs be suspended during the election period, and that as Article 35 of the Constitution safeguards the right to information, the required openness made a case for projects and activities to be held accessible to all. In further support of the respondent's stand is the affidavit by Davis Chirchir, sworn on the 24th of August 2017. He avers that the collation of election results Form C and the announcement thereof was done after all Forms 33B, save as regards Nyando constituency, had been electronically transmitted to the National Tallying Center. He deponed, in line with the deposition of Ms. Gushu, that the voting results for Nyando constituency, which had not been collated at the time of results declaration, had no effect on the outcome. The deponent averred that, quite contrary to the reprobation of the vote result transmission measures taken by the Commission, the actions taken had been based on the authority of the law. This transmission question had already featured in a High Court decision where it was held that the first respondent had duly put in place a complementary mechanism in terms of Section 44A of the Elections Act 2011, and that it had, with public participation, established regulations to operationalize the said statutory provision. In this context, the deponent averred that any failure of the technological devices would not impair the electoral process or become the basis for invalidity of the electoral process. The deponent averred that the petitioner's claim that the security of the integrated electoral management mechanism had been compromised was not substantiated with any transcripts or video clips or any other material reference. The deponent averred that the first respondent in full control of its electronic transmission system at all times, and that no evidence showed it to have ceded its management or authority in that regard to any third party. He deponed that it was not true as alleged that the transmission of those 11,000 polling stations had been compromised, especially as none of the petitioners had contested the contents of Forms 34A from the relevant polling stations. He further averred that it would not be true, as alleged by the petitioners, that a total of 1,000 polling stations would represent as much as 7,700,000 voters, given that the number of registered voters per polling station varied from 1 to a maximum of 700. The deponent deposed that it was not a factual statement coming from the petitioners, that the IEBC had the election results streamed on the website represent a constant percentage of 54% and 44%, respectively, for the third respondent and the first petitioner. Instead, the variation between the two had oscillated between 27.06% and 9.22% in favor of the third respondent. The perception on the electoral process as a whole was that the third respondent had been duly elected in a free, fair, credible, and valid election conducted on the 8th of August 2017. Now, does the petitioner's case rest on fact? Have they discharged the burden of proof? Did the respondents discharge the evidential burden? Who is by the state of the evidence? The objective merits of this case must be drawn from the foundation of fact. I will subsequently revert to the vitality of fact in the configuration of jurisprudence. The juristic and scholastic preoccupation with the essence of the law and its defining role in social, economic, political, religious, or other crucial human engagement. Fact is thus defined, quote, something that actually exists, an aspect of reality, end of quote. Fact, therefore, is as reliable as the concrete foundation of a skyscraper, and it is to be counted upon as a basis of objectivity and truth. The practice of law, and more particularly the motions of the judicial process via the minds and hands of judges, society's trustees for justice, are invariably lodged upon the pillars of fact, this being proffered through evidence. The merits of the petitioner's case stand to be tested in the first place through evidence. What evidence did the petitioners adduce? And did they discharge their initial burden of proof and complete it with an effective clearance of legal burden resting upon them? The evidence scenario speaks for itself, as may be summarized here. 1, the petitioners resort to broad assertions of alleged wrongs on the part of the first and third respondents. 2, such alleged failings are lined up against the Constitution's prescriptions of certain values, principles, and norms. 3, the petitioner's statements are often plaintive and inviting the court to ascertain their true scope in terms of legality and propriety in the measures taken by the respondents. 4, what petitioners present as fact relates primarily to the electronic transmission of election results rather than the physical conduct of voting and enumeration of ballots. And what the petitioners present as fact in relation to polling day and to the count of votes has been responded to in substantial detail in the consistent evidence emanating from the respondents. 6, opponents on the respondent side have responded to the statements from the petitioner side. They have given testimony describing their actions in the conduct of the general election of the 8th of August 2017 as regards the tally and count of votes and the recording, transmission, and declaration of results. The respondents have in the process explained the actions they took just before, in the course of, and in the aftermath of voting day, explaining some impediments as affected the electoral process and invoking specific provisions of the Constitution and the law by virtue of which they acted. Does one behold a clear evidence scenario such as ought to lead a perceptive court in some particular direction, of course barring some weightier consideration of justice which compels a different course? From the evidence, the petitioners do not seek ascertainment of the true number of votes cast for the first petitioner and for the third respondent, even though these, as required by law, had been delivered to the Supreme Court and are kept in the custody of the registrar. The petitioners have focused the burden of their case on apprehensions as to the perfect security of the transmission system, whereby the election results had earlier been relayed before the physical records were received, organized, and kept by the first respondent. They have claimed an improper tallying of votes from different polling stations, though this has been denied on the basis of specific evidence and exhibits showing the contrary. They have spoken of proper conduct during election on the part of certain government officials, said to have unduly benefited the third respondent's electoral platform, but these claims have been denied by witnesses for the respondents. The of such averments have been brought to question by the detailed testimony of the respondents' witnesses, Dr. Kibicho and Mr. Wakahio. The attributions to the third respondent of improper influence, intimidation, and corruption, therefore, are not just unsubstantiated, but also fail to meet the high standards of proof required for criminal charges. The petitioners assert in broad terms the first respondent in the conduct of elections did not abide by the terms of Article 86 of the Constitution, which requires elections to be conducted in a manner that is simple, accurate, verifiable, secure, accountable, and transparent. Yet the use of the manual ballot paper would clearly meet such conditions. The voter has no difficulty in marking it. Its reality and visibility is not in doubt. It is verifiable as a check. It reveals the voter's exercise of his or her right of choice. It is secure, it is transparent, it is accountable. The votes cast had been announced at the polling stations, where they were tabulated and results announced. From that initial ascertainment of the voting situation, the results were collated at the constituency tallying center and announced at that level. The first respondent thereafter provided Forms 34A from all polling stations, Forms 34B at constituency tallying centers, and Forms 34C at the National Tallying Center, which was signed by all the presidential election agents save for the petitioner's agent. Thus, from the evidence in this court record, the claim of non-compliance with the terms of Article 86 of the Constitution does not stand up. More substantial and more persuasive evidence, in my perception, has emanated from the respondent side. Several examples of such evidence may be set out here. One, Mr. Chebukati, who had been the returning officer for the presidential election, gave testimony that the verifiable physical count of the votes cast showed that the third respondent had garnered 8,203,290 votes, as against the first respondent, who received 6,762,224 votes. And these results were duly recorded in Form 34C, which was itself abstracted from Forms 34B, forwarded to the National Tallying Center from the constituency tallying centers, as well as the diaspora vote tallies. Two, Mr. Chebukati deponed that the primary results declaration forms, Forms 34A and 34B, had in no way been compromised as regards their accuracy and overall integrity. He deposed that the Forms 34B had been duly forwarded from the constituencies to the National Tallying Center for verification with Forms 34A and for tallying. Three, Mr. Chebukati deponed that the Commission had taken all the necessary steps to ensure that the general election in all its components complied with the constitutional requirements of simplicity, accuracy, verifiability, security, transparency, and accountability. Four, Chebukati's averments are specific, matter of fact, and in line with vital evidence emanating from other deponents on the respondent side. For instance, Mr. Chiloba, the first respondent's chief executive officer, confirms that the tallying and transmission of results took place at the polling stations, after which the vote count was collected and declared at the Constituency Tallying Center and the National Tallying Center. Mr. Chiloba gave a clear account of the transmission system used by the first respondent, as well as the context and modalities of the recently introduced Kenya Integrated Electoral Management System, KIMS. 4. Mr. Muhati, in his affidavit, gave still more detail of the electronic transmission system, an account that was entirely consistent with the averments of both Mr. Chebukati and Mr. Chiloba. 6. Specific and credible evidence in relation to the factual situation attending the conduct of the general election of the 8th of August 2017 is recorded by other deponents, such as Ms. Immaculate Kasait, the third respondent, Mr. Wakahyu, Ms. Gushu, Mr. Chirchir, Dr. Kibicho, Mr. Omwenga, and Ms. Kigen Sorbet. Judges entertaining the competing claims of parties constantly to form an opinion and from objective criteria and conviction eliminate the credible from the incredible, the truth from the untruth. That has to be done in this instance. The factual accounts of the respondents are firm and gripping. They are credible and represent the substantial truth. However, no account of equal strength is beckoning from the other side. I cannot but conclude that on the facts conveyed through evidence in support of the petitioner's case, they are on weak grounds as compared to the respondents. In establishing the merits of their case, the petitioners had both the ultimate legal burden of proof and the shifting evidential burdens falling upon them. They did not, in my appraisal, discharge even the early evidential burden, the effect being, in the end, that they made a valid case against the respondents. The law of burden of proof at the beginning and in the course of trial has been the subject of scholarship, and I cite Dr. H.F. Morris. Quote, the distinction is made by commentators on the law of evidence between the use of the term in the sense of the burden which lies throughout the trial of establishing a case, usually called the general burden of proof, and in the sense of the onus of producing evidence at any particular stage during the trial. There is a general burden of proof which lies throughout the trial upon one of the parties and never shifts to the other to establish the case. In a civil case, this burden lies upon the party who would lose if no at all were to be produced. That is to say, in order to win, he must establish his case by a preponderance of evidence, and coupled with the onus of discharging this burden is his right to begin, end of quote. Such a position is reflected in Kenya's evidence. 80, Laws of Kenya, Section 107, quote, whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist, end of quote. Now, leaving the issue of evidence, now we have to consider whether perhaps the petitioners have any other case based elsewhere than upon evidence. How is the court to be guided in relation to the petitioner's claims that, quote, the presidential election was so bad, administered and managed that it failed to comply with the governing principles established under Articles 1, 2, 4, 10, 38, 81, 82, 88, 6, 88, 138, 141, 63, and 249 of the Constitution, the Elections Act, and the regulations made thereunder, including the Electoral Code of Conduct, end of quote, and in relation to the assertion that, quote, the massive, systemic, and deliberate non-compliance with the Constitution and the law, quote, goes to the very core and heart of holding elections as the key to the expression of the sovereign will and power of the Kenyan people, end of quote, undermines the foundation of the Kenyan system as a sovereign republic where people are sovereign under Article 4 of the Constitution, end of quote, and severely undermines the very rubric, literal, and framework of Kenya as a nation state, end of quote. Question mark. How is the court to be guided in respect of the petitioner's claims that the presidential election contravened the principles of a free and fair election under Article 81E of the Constitution as read with Section 39 of the Elections Act, end of quote, that, quote, the entire process of relay and transmission of results from polling station and national tallying center and from the constituency tallying centers to the NTC was not simple, accurate, verifiable, secure, accountable, transparent, open, and prompt, substantially compromised and offended the requirement of free and fair elections under Article 81E, 4, and 5 of the Constitution. Quote, the data and information recorded in Forms 34A and the individual polling stations were not accurately and transparently entered into the KIMS at the individual polling station, end of quote. The presidential election was not administered by the first respondent in an impartial, neutral, accountable manner as required under Article 81E, 5 of the Constitution, end of quote, that, quote, the first respondent abetted and allowed the electronic media and news channels to relay and continue relaying the purported results which the first respondent was aware had no legal basis or factual basis, end of quote, as well as other claims similarly couched. That's the question. How is the court to be guided? Such claims invoke the question as to the first respondent's compliance with the law in every detail, though without necessarily adverting to the objective facts as borne by the evidence. The court has to consider whether such contentions should be a basis for annulling the outcome of the presidential election of the 8th of August 2017. This takes us to the line of jurisprudence now established in electoral matters. The Constitution of Kenya 2010, which represents the people's much-labored initiatives to find a pacific, rational, and humane structure for governance, bears certain principles, and it safeguards certain rights and values in unambiguous terms. It safeguards, quote, the rule of law, democracy, and participation of the people, Article 10(2)A. It safeguards political rights in detailed terms, which include the provision, Article 38(3)B and C, that every adult citizen, quote, has the right, without unreasonable restrictions, to vote by secret in any election and to be a candidate for public office, and if elected, to hold office, end of quote. Such sacrosanct safeguards have to be so interpreted as to accord them true meaning. The same Constitution entrusts the interpretive mandate to the courts, to which, for the faithful discharge of the task, the voters have entrusted their adjudicative sovereignty. Constitution, Article 1(3)C. how are the courts to interpret such rights and safeguards? The answer is provided in the Constitution itself, Article 20, Sub-Article 3. Quote, in applying a provision of the Bill of Rights, a court shall adopt the interpretation that most favors the enforcement of a right or fundamental freedom, end of quote. And if it is the Supreme Court that is undertaking such interpretation, then just like the other courts, it is under obligation, Article 24A, to promote, quote, the values that underlie an open and democratic society based on human dignity, equality, equity, and freedom, end of quote. The Supreme Court, just like the other courts, in the course of performing its safeguarded interpretive mandate, is under obligation, certainly in the straightforward case, to be guided by the principle that, quote, justice shall be administered without undue regard to procedural technicalities, end of quote. Article 159(2)(d), and the principle that, quote, the purpose and principles of this Constitution shall be protected and promoted, end of quote, Article 153(2)(e). The Constitution enjoins all courts in the exercise of their interpretive mandate to adhere to certain well-defined paths, these being a manner that, quote, promotes the Constitution's purposes, values, and principles, end of quote. B, a manner that, quote, advances the rule of law, the human rights and fundamental freedoms in the Bill of Rights, end of quote. C, a manner that, quote, contributes to good governance, end of quote. The foregoing prescriptions, in the context of the exercise of the people's electoral rights, as took place on the 8th of August 2017, are the firm foundation upon which I have founded my dissent from the majority opinion in this critical election petition. The majority decision, in my considered opinion, has not only done short shrift to the governing terms of the Constitution, but also failed to adhere to the clear path of the law which has evolved, including this court's precedents on electoral law. Just as with the Constitution itself, so with the regulatory sets of norms, including the statutes and regulations, they all fall to the interpretive mandate of the courts. These facts, on the plane of legal scholarship, ought to be apprehended as the inherent common law chain that runs through the motions of judicialism in Kenya, as in so many other countries of the Commonwealth. The long-established rationales of the judicial method remain with us today, and they ordain the espousal of the doctrine of precedent, a universal concept which indeed is expressly replicated in the Constitution of Kenya 2010. Thus, this Constitution stipulates, Article 163(7), all courts other than the Supreme Court are bound by the decisions of the Supreme Court. The Constitution prescribes competence in common law principles as prerequisite in the appointment of judges in the following terms. Article 166(2), each judge, quote, each judge of a superior court shall be appointed from among persons who hold a law degree from a recognized university or are advocates of the High Court of Kenya or possess an equivalent qualification in a common law jurisdiction, end of quote. The common law interpretive method is the constant milieu within which the application of Kenya's electoral law, beginning from the Constitution to the subsidiary legislation, is to be apprehended. Once the judge accomplishes the task of interpreting the electoral law as provided in the Constitution, the judge comes down to a whole set of statutes and regulations, the latter category comprising the Supreme Court Act, the Appellate Jurisdiction Act, the Elections Act, the Election Campaign Financing Act, the Election Offences Act, the Independent Electoral Boundaries Commission Act, the Political Parties Act. How has the court interpreted such laws? Where is the Supreme Court's earlier work recorded in that regard? And since the applicable law is a pertinent one for each electoral dispute, what is the current state of the law? How does such law apply in relation to a petition before the Supreme Court in relation to the general election of 8th August 2017? Does such law affect the presidential election of that date differently from the manner in which it affects 5 sets of elections of the same date? Case law, the law as interpreted and applied by judges on the recorded merits of each matter, has forever been the cornerstone of the common law. It is precisely the common law's focus on authentic appraisal of the facts of each case that made it ever so compelling as a defining strand in the judicial contribution to progressive modern governance in conditions of democracy. Jurisprudential for the foregoing standpoint is found in the work of a distinguished Justice of the Supreme Court of the United States of America, Benjamin Nathan Cardozo, 1870 to 1938, in his book, The Nature of the Judicial Process. And he says, from page 28 to 31, quote, "The problem which confronts the judge is a twofold one. He must first extract the precedents, the underlying principle. He must first extract from the precedent the underlying principle, the ratio decidendi. He must then determine the path or direction along which the principle is to move and develop. Cases do not unfold their principles for the asking. They yield their kernel slowly and painfully. The directive force of a principle may be exerted along the line of logical progression. This I will call the rule of analogy, or the method of philosophy. Along the line of historical development, this I will call the method of evolution. Along the line of the customs of the community, this I will call the method of tradition. Along the line of justice, morals, and social welfare, the mores of the day, and this I will call the method of sociology." End of quote. Such challenges of adjudication dictate that the gains of the past, authoritative interpretation by a discerning and responsible court, be perceived as representing a precious juristic civilization, and these therefore keeps as a reference point for the conscientious and effective resolution of later disputes. Now, the judicial approach in the sphere of electoral law is obviously inseparable from the Constitution's values and principles of democracy. It thus behoves us to pay due deference to the fundamentals of the sets of cases that have in the last several years been determined by this Supreme Court on the subject of elections, including presidential elections. Such is quite conclusively the most dependable course of the law that this country's lawyers must engage in the first place. In Raila Odinga and others against Ahmed Isaac Hassan, petition number 5 of 2013, this court took into account the nature of the governance mandate under the Constitution, and in response to a challenge to the integrity of the presidential election laid down a set of guiding parameters. The court said as follows, quote, "An alleged breach of an electoral law which leads to a perceived loss by a candidate takes different considerations. The office of president is a focal point of political leadership and therefore a critical constitutional office. This office is one of the main offices which in a democratic system are constituted strictly on the basis of majoritarian expression. The whole national population has a clear interest in the occupancy of this office, which indeed they themselves renew from time to time through the popular vote," end of quote. Flowing from the crucial majoritarian factor in the filling of the primary office of the executive branch, the court in that case defined its orientation as regards the resolution of an electoral dispute, such as the one which has now come up before us. Quote, "As a basic principle, it should not be for the court to determine who comes to occupy the presidential office, save that this court, as the ultimate judicial forum entrusted under the Supreme Court Act 2011 with the obligation to assert the supremacy of the Constitution and the sovereignty of the people of Kenya, must safeguard the electoral process and ensure that individuals accede to power in the presidential office only in compliance with the law regarding elections," end of quote. The foregoing principle, in this Supreme Court's perception, dictated that even though the court must uphold the clear electoral mandate, it will hold in reserve the authority, legitimacy, and readiness to pronounce on the invalidity of the occupancy of the presidential office in case there is any major breach of electoral law, end of quote. The foregoing point regarding the Supreme Court's obligation of vigilance is expressed still further in another paragraph. Quote, "The judiciary in general, and this Supreme Court in particular, has a central role in the protection of the Constitution and the realization of its rights. So this may inure to all within our borders. And in the exercise of that role, we choose to keep our latitude of judicial authority unclogged. So the Supreme Court may be trusted to have a watchful eye over the play of the Constitution in the full. Even as we think it right that this court should not be a limiting factor to the enjoyment of free political choices by the people, we hold ourselves ready to address and to resolve any grievances which flow from any breach of the Constitution and the laws enforced under its umbrella." End of. Such guiding principles were clear enough and, in my perception, were attended with special merit. These principles today represent the vital backdrop to Kenya's electoral law. In the foregoing case, the court suo motu undertook a sample retallying of votes, coming to the conclusion that, quote, "By no means can the conduct of this election be said to have been perfect, even though, quite clearly, the election the greatest interest of the Kenyan people, and they had voluntarily come out in the polling station, to the polling stations for the purpose of electing the occupant of the presidential office." End of quote. The court, while being mindful of the several imperfections noted during the sample retallying, mainly directed its mind to the emerging majoritarian intent, asking itself the following question before upholding the election outcome in that case, quote, "Did the commissioner clearly and decisively show the conduct of the election to have been so devoid of merits and so distorted as not to reflect the expression of the people's electoral intent?" It is this broad test that should guide us in this kind of case in deciding whether we should disturb the outcome of the presidential election, end of quote. The precedent-setting decision was distinctly endorsed by subsequent electoral dispute cases, and it must now be regarded as part of the scheme of electoral law in Kenya, founded upon a beneficent interpretation of the Constitution and of the whole body of electoral law. This point, for good measure, is consistent with the comparative adjudication experience in election matters. As the retired Israeli Justice of the Supreme Court, Aharon Barak, in his book, The Judge and Democracy, observes, quote, comparative law can help judges determine the objective purpose of a constitution. Democratic countries have several fundamental principles in common. As such, legal institutions often fulfill similar functions across countries. From the purpose that a given democratic legal system attributes to a constitutional arrangement, one can learn about the purpose of that constitutional arrangement in another legal system. Indeed, comparative constitutional law is a good source of expanded horizons and cross-fertilization of ideas across legal systems. End of quote. On such a basis or principle, the law and practice in the United Kingdom of Great Britain may be cited for its relevance in the instant case. An apt summary of that position by a distinguished scholar, Stanley Alexander D. Smith, who was Downing Professor of the Laws of England in the University of Cambridge, in his book, Constitutional and Administrative Law, 3rd edition, 1977, page 252. And he says, quote, petitions based on irregularities at elections are now extremely rare. This is partly because very close contests are uncommon. And even if the court finds that irregularities were present, it may determine that the results ought to stand, since they were unlikely to have affected the results. End of quote. Such a state of the law is reflected in yet another decision of this Supreme Court, Munya against Kithinji and 2 others, Supreme Court petition number 2B of 2014. And this is what we said in this court, quote, if it should be shown that an election was conducted substantially in accordance with the principles of the Constitution and the Elections Act, then such election is not to be invalidated only on the ground of irregularities. Where, however, it is shown that the irregularities were of such a magnitude that they affected the election result, then such an election stands to be invalidated. Otherwise, procedural or administrative irregularities and other errors occasioned by human imperfection are not enough by and of themselves to vitiate an election. On the same principle, the Supreme Court thus held in Kidero and 4 others against Waititu and 4 others, Supreme Court petition number 18 of 2014. Quote, generally, an election can only be declared void if the election did not substantially comply with the written law. In this regard, the Constitution, the Elections Act, and the regulations made thereunder, and any other relevant law, and where there is substantial compliance with the written law in an election, the irregularities must indeed have affected the result of the election for that election to be invalidated. End of quote. Yet another authoritative decision of this court, Obado against Oyugi and 2 others, Supreme Court petition number 4 of 2014, quote, although the Court of Appeal cited the decision of this court in the Rael Odinga case, it did not apply the principle that a court should consider the effect of the irregularity in the contested results. This principle holds that irregularities in the conduct of an election should not lead to annulment, where the election complied with the applicable law and the results of the election are unaffected. End of quote. The Supreme Court ever so clearly defined the operative electoral law on the basis of the Raila Odinga petition of 2013 in subsequent petitions. The court was scrupulously affirming the synchrony of two express edicts of the Constitution of Kenya 2010 in Article 1.3 and Article 159.1, the first defining the sovereignty of the people, the second delimiting the judiciary. By Article 1.3, the people's sovereign power is partly delegated to, quote, the judiciary and independent tribunals, Article 1.3c, while Article 159.1, which constitutes the judicial authority, says, quote, judicial authority is derived and vests in and shall be exercised by the courts and tribunals established by or under this Constitution. The foregoing principle was constantly reflected in the Supreme Court's decisions rendered in 2013 and after, as is exemplified in the case George Mike Wanjohi against Stephen Kariuki and two others, Supreme Court petition number 2A of 2014, where this court said, quote, this court should in principle not substitute a sitting elected representative with another without allowing the people their political rights as enshrined under the Constitution. To do otherwise would be to undermine the values and principles of democratic governance that bind us in the execution of our judicial authority. It would also lead to an in the composition of the elected office holders who bear the people's sovereignty and who stand out as a clear disregard of the founding provisions of the Constitution, end of quote. In hindsight, the following passage in Mike Wanjohi touches on the very nub of judicial responsibility as it relates to the sovereignty of the people who established the totality of the current governance system through the Constitution of Kenya 2010. It hence follows that the general guiding path for the disposal of electoral disputes, such as the instant one, could not have been stated more conscientiously and more effectively than in that case, as follows, quote, by the design of the general principles of the electoral system and of voting in Articles 81 and 86 of the Constitution, it is envisaged that no electoral malpractice or impropriety will occur that impairs the conduct of elections. This is the basis for the public expectation that elections are valid until the contrary is shown, end of quote. A consideration of the merits of an electoral petition, such as the instant one, therefore, takes one straight back to the evidence tendered. So we get back to evidence. And hence, inseparable link between institutional principle and the pillars of evidence. Since, as I have already determined, the petition herein fails on the pillars of evidence, it becomes clear that the majority decision lacks validity from the standpoint of governing principles. Evidence is the bearer of telltale signs of electoral victory or of electoral defeat. The physical form of the ballot is directly visible and is readily subjected to the test of simplicity, accuracy, verifiability, security, accountability, and transparency. This physical evidence quite clearly is the natural starting point in ascertaining who has won an election, and hence the majority judgment would have been expected to begin from a foundation of numerical assessment before invoking any other parameters. For such other elements are essentially subjective and are inherently destined to compromise the sovereign will of the voters, which the Constitution expressly suffices. Only from such a foundation of the physical vote count does one secure a proper viewpoint for the other dimensions of the electoral process, including the credibility of the entire operation. Indeed, in view of the strength of the evidence emanating from the two sides, the only objective conclusion would have been that, within the measure of the possible, the conduct of the election by the first respondent was entirely credible. The emerging principle regarding the initiation of claims by way of election petitions is that all proof should commence from the foundation of the physical ascertainment of voting records. All other claims then must revolve around that pillar and must establish that some gross impropriety had affected the electoral process and should lead to its annulment. I am constrained to propose this scheme as a proper for the reform of Kenya's electoral law. Such legal reform would need to institute all appropriate security backups around the physical records and would ensure the establishment of safety nets around the votes cast. The instant case has evoked intense national debate involving professionals, politicians, observers, and others. The consequence being a justification in this judgment for a clarification of the implications of judicial intervention in situations that entail the legitimate exercise of the citizens' momentary inclinations on matters of politics and daily exigency. Falling squarely within such a category are the people's legitimate preferences. What is the proper stand for the Supreme Court in such matters? How does the judge's requisite approach relate to the majority decision in the instant petition? My consideration of such issues confirms my position in this dissenting judgment. By Article 1, Article 1 of the Constitution, is provided the judiciary, quote, the judiciary shall be subject only to this Constitution and the law, and shall not be subject to the control or direction of any person or authority, end of quote. The Constitution, while safeguarding the judiciary's adjudicatory space, entrusts certain governance spaces to other agencies, primarily the legislature and the executive. And this is the basis for the constitutional principle known as the separation of powers, a principle the validity of which in the Kenyan constitutional order has not ever been seriously contested. The judiciary is a trustee of the people's sovereign power, Article 1(3), with regard to the interpretation and application of all all the terms of the Constitution and of all other law. Clearly, a substantial initiative in the motions of the entire sphere of law, legality, and jurisprudence has been reserved to the courts. As the outer limits of such reserved competence has not been specified in express terms, it follows that the frontier areas of such power, at least potentially, admit of conflicting interpretive approaches. But, as already noted, the proper trustee of the boundary delimiting ethics must be the judiciary, an arm of the state which is endowed with the special facility of juristic values, objective criteria of conflict resolution, such as facilitates professionalism, justice, and fairness, and the benefit of access to relevant comparative lessons. The judiciary, in the exercise of such an exclusive mandate, ought to enter upon its task by taking into account the uncontestable reserved remits of the other agencies of the state. The people, in exercise of their sovereign power, have expressly delegated some of that power to Parliament and the legislative assemblies in county governments. Article 1.3a exclusively entrusted some of their sovereign powers to, quote, the national executive and the executive structures in county governments, end of quote. There is no basis for abridging Parliament's power and mandate. For the Constitution, Article 94.1 prescribes that, quote, the legislative authority of the Republic is derived from the people and at the national level is vested in and exercised by Parliament, end of quote. Similarly, there is no basis for detracting from the general character of the executive power. Article 1291 prescribes that, quote, the executive authority derives from the people of Kenya and shall be exercised in accordance with this Constitution, end of quote. Unlike the judiciary, the work orbit of which is lined up with laws, principles, and jurisprudential yardsticks, both the legislature and the executive, in view of their electoral and policy foundations, may quite properly be described as political agencies. They relate to the largest number of Kenyan people in close and direct proximity. They influence and are influenced by the momentary concerns, which therefore justify the conception and espousal of policy and politics conceived and executed in short time frames. This is in stark contrast with the relationship between the ordinary citizen and the courts of law. And if the courts overlook this reality, it will constitute a groundswell for failure of judicial in line with the professional juristic remit. The prolonged history of judicialism in all democratic countries demonstrates that the proper role of the courts has been professional, judicial, and founded upon cardinal principles which draw lines of correctness and propriety in situations of dispute, so as to secure a certain optimum level of safeguards for the rights of the citizen. Beyond that level of safeguard and fulfillment, it falls to the political agencies to pursue constantly such policy stance as will satisfy and give fulfillment to the national populace. On these principles of institutional disposition, it follows not to the court to make undue haste in assuming the policy and political mantle, as stampede is destined not only to disrupt the delicate institutional balances, but to weaken the reliable jurisprudence prudential bedrock which assures the citizens of an ultimate governance safety net. In the context of the foregoing reasoning, it follows, in my view, that the majority on the instant petition has made a precarious move that is destined to prove detrimental to the dependable setting of relations among essential governance entities, to the detriment of the rights and legitimate expectations of the citizen. What the majority has said is set out, and you have already seen it, and they have made their orders in a manner that you know. Such a determination is in clear departure, in the first place, from the state of the evidence. As already indicated herein, the petitioner's case rests on just one dimension of the electoral process: electronic transmission of results. Moreover, the bulk of the assertions made as regards transmission is just that, contentions with only limited testimonial ingredient. It is hardly evidence, what Black's Law Dictionary calls something including testimony, documents, tangible objects, that tends to prove or disprove the existence of an alleged fact. That is evidence which I'm looking for. On the other hand, evidence in the true sense, a set of probative facts, is what came forth from the respondents. And its tenor and effect was that there were only limited instances of failure of resource transmission, only limited cases of irregularity, vote addition and tabulation, not affecting the ultimate compilation and summation. The lawful complementary device was put in service in cases of failure in the transmission process. All the physical voting records were avoidable, and indeed had been timeously availed to the Supreme Court registry. All the physical voting records were available and indeed had been timeously availed to the Supreme Court registry and could have been recounted to confirm the third respondent had been properly declared as president or not. Thus, on basic elements of trial, the essence of burden of proof was undischarged, and it was in effect of the conventional process of judicial inquiry and determination, making a finding in favor of the petitioners. Secondly, the majority would appear to have taken leave of the juristic obligation to interpret the terms of the articles of the Constitution invoked by the petitioners. The obligation to break this down so as to ascertain the discrete demands of the law. The obligation to consider the pertinence of the specific of evidence from the petitioners, such as would answer to the constitutional and legal principles invoked. Thirdly, the majority departed, as it would seem, from the placid frame of the juridical setting and assumed direct responsibility yet calls of policy or politics by altering the design of momentary popular inclinations which are, by the terms of the Constitution, legitimate in all respects. The damage such as may flow from such a deportment is not yet plain to all, as is quite clear from common perceptions recorded in the media ever since the delivery of the majority judgment. I can quote just one. Quote, "What we have experienced as a nation is devastating. The recent ruling by the Supreme Court to nullify a presidential election has never happened before in the history of this nation, or even this continent. But it is undoubtedly a political and judicial shift that has risen from the years of tectonic plates of power on each other within a constricted democratic space, end of quote. The general perception associates the majority judgment with an overtly political inclination. This precisely judgment's obvious departure from the professional plane of jurisprudence as the proper platform of the judicial arm of the state. The majority position would, of course, make history emanating from basic principle, and in this regard, I cite a passage from a distinguished scholar of history, Professor Goat. He says, quote, "To tell the story of a past so as to portray an inevitable destiny is for humankind a need as universal as tool-making. To that extent, we may say that a human being is by nature historicus," end of quote. So, by, quote, "the magic jolt of the 1st of September 2017, general political history would have been made, even though, as I maintain, this represents a departure from the jurisprudence of democratic systems, which so much cherishes the separation of powers and which so studiously commits the judiciary to the professional task of line drawing to ensure the sustenance of regular safeguards of the Constitution and the law for all. In future inquiries, it may be established that the law, as advanced by its interpreters and scholars, has its anchorage on the adjectival plane from which it addresses the primary motions of social, economic, and political activity: agriculture, architecture, engineering, land development, seafaring, sport, transport, communications, and so on. The law stands to be formulated, molded, interpreted, and applied, not for his own sake and in his own course, but in relation to the said primary motions which preoccupy citizens and communities. Thus, in the instant case, the electoral process had taken place, and now its motions had to be matched to the law as interpreted. By the interpretive scheme of the law, it does not stand the test of rationality or efficacy to merely allege some unspecified impropriety in the electoral process. The relevant clause of the Constitution must be taken through an analytical process and subjected to definite categorizations which crystallize the specific concept and elements said to have been violated. By this criterion, most of the contentions of the petitioners in the instant case, on account of their broad generality, would not stand up. The interpretive task, as it thus relates to the adjectival essence of the law, is inherently professional and is reflected in the concept of jurisprudence, which means, in the words of a distinguished scholar, R.W.M. Dyers, it deals with thought about law. The court, in the normal framework of its role under the Constitution, is engaged in the specialized process of jurisprudence. It follows that the more immediate, urgent, and primary motions of basic policy making inherently devolve the political arms of the state rather than the more specialized entity which is the judiciary. This judgment, apart from the occasion it proffers for a reflection on the law relating to elections, is a basis for a rethink on law as a concept and as a professional engagement defined in a regulatory framework applicable to the citizens' primary undertakings. From such a platform, it emerges that the law's design in the hands of the judge, the lawyer, the scholar, rests in with the fundamentals of constitutional governance, an important element of which is the independence of the judiciary. On the basis of this principle, it is to be recognized that the judge's proper mandate lies several removes from the citizen's parliamentary policy and political desires and expectations, which generally devolve the political arms of the state. By this perception, the judge's proper remit has its focus upon professional engagement founded upon objective scenarios of the period. Such a perception of law and legal process, in retrospect, will be found to be in conformity with the analytical schemes that mark the dedicated works of great jurists of the past. And in this regard, I would mention, I've given references: Lord Mansfield, Professor Frederick William Maitland, Lord Atkin, Justice Oliver Wendell Holmes, Justice Benjamin Nathan Cardozo, Professor Stanley Alexander D. Smith, Lord Denning. The special contribution of these judges and law scholars was to light up the orbit of jurisprudence as a dedicated sphere of thought, learning, and preoccupation that secured the requisite motions of the different spheres of human activity, while affirming the perceptions of integrity and propriety. Such is the jurisprudential context in which I have considered the petition hearing. The majority decision, in effect, holds that the court may quite directly change the course of national history through a precipitate assumption of recurrent policy making or political inclinations and mandates. In my considered opinion, judges, where the making of history devolves to them, should focus their place upon the intellectual and jurisprudential domain, rather than upon the workaday emotions of general policy and politics, which devolve to the citizens themselves and to the political agencies of the state. On these principles, on these premises, I hold that the majority decision fails to resonate with the Constitution and the law, and with all relevant guiding principles, I would dismiss the petition with costs. That is the decision that I have given.
Thank you very much, Justice Ojwang. Now,